I must say that I heard that oil and gas, it sounds sexy and means big money. So before I come to this sexy subject, I would like to, of course, thank very much for the invitation here. And for me, this is especially important thing because I spent here quite a number of months as a visiting scholar, exactly in this college, working on my habilitation. So for me, speaking right now from this position is a very big honor. I would like to focus, this will be as a little bit as an addendum for this what Wendy was speaking. She was speaking in the big picture about the new challenges in the oil and gas, and especially the switching into the role of the states in this dispute resolution because of the natural capacities of the states in the process of producing, extracting the natural resources. So I would like to focus on Energy Charter Treaty in relation to oil and gas as well, but in this very stormy point, which was made in March this year, it means ACMEA case. Our Lord Mansi, he talked a little bit about this, but that was a very important moment. And this is like a borderline for all of the investment cases if you are talking about the intra-EU cases. Well, my feeling is that most of the cases, most of the disputes in oil and gas is really resolved in the commercial arbitration. Nevertheless, there is a number of very important issues which are resolved also in investment arbitration, and Energy Charter Treaty, even by its name, is important in this respect. It is a very special creature. I must learn, sorry, how to do it. Okay, this is a very special creature. It is called a mixed agreement. It is a special if you compare it with other BITs, with other treaties, because not only there is 27 EU states and third countries which are party to this treaty, but there is also EU by itself. So EU is a partner to this treaty, what makes a picture a little bit different if you are concerning IKEA case. I must say I was looking how many of the gas and oil cases were resolved under the treaty, and this is I have found that there is 22 oil and gas treaties, and 5 of them, which are named here in this slide, they are the intra-EU BITs. Well, they really relate to many things, to various things, including the legislative amendments of the price regulations, the damages in the process of operation of the refinery due to the government actions. There were irregularities in granting licenses, and there was the restrictions on licensing oil and gas exploration that really related also to the Italy. So, therefore, I was thinking, what could be next? And I thought that I was not thinking about in such a big picture as Wendy about all of these protective measures. I was thinking that, well, the first thing what was coming to my mind, if you are talking about the EU disputes which may relate to gas and oil, this is of course Nord Stream 2. Very sensitive, very political. It can really generate certain problems. Of course, I do not wish the parties which participate in this project to have disputes. Nevertheless, it is some area where the disputes may arise. You have here in the slides also the parties. Well, this Nord Stream 2, it goes from Russia, which is not EU, obviously, but it goes to Germany. So it touches the territorial waters of Germany, probably optionally also Denmark, and the exclusive zones from Finland and Sweden. And there are a number of entities which are involved, which come from EU. And this is Uniper, Wintershall, NG, MV. Gazprom is not EU as well. But he participates in this project as Switzerland. So basically, there is a number of matters which may arise and which might qualify to be the intra-EU dispute. Let's take, for example, even the United Nations Convention on the Law of the Sea, where the coastal states have certain powers to limit laying of the pipelines, to take certain reasonable measures in order to prevent the pollution. And we lawyers, we love especially such wording like reasonable measures. Reasonable measures, this is one of our beloved expressions, because we can then dispute a lot what will be reasonable and what will not be reasonable. Then we come to March. We come back to March this year, and we are faced with the issue of ACMEA. As it was mentioned by my predecessor, the ACMEA made certain conclusions as concerning application of the EU law by the Arbitral Tribunal. Basically, there were three questions which were raised in these proceedings. Coming back, there was the Slovak ACMEA versus Slovak Proceedings. The jurisdiction objections were raised by the Slovak state in the process of the arbitration. They were they were rejected, and then again they were raised in the setting aside level, and the German court turned to the European Court of Justice in order to find out, to confirm whether this jurisdiction of the arbitral tribunals under the BITs is a viable vehicle. And the court said no, basically. It means it considered the application of Article 344, that was the first question. It means the provision which provided that the party states do not submit their disputes as concerning interpretation of the application of the treaty, of the Lisbon Treaty, to another body than it is foreseen by the Lisbon Treaty. It means the judicial system which is designed by this treaty. The second question, which was together judged, was 267 article of the Lisbon Treaty, which is about the exclusive jurisdiction of the European Court of Justice to make interpretation in order to provide the harmonized application of the law. The court basically said that the allocation of powers is only can belong to the judicial system, it means to the courts, not to the arbitration tribunals which are appointed in accordance with the BITs, in this case the Slovak BITs, and the only courts are equipped with the powers to raise the preliminary questions. Therefore, the arbitral tribunals, they cannot interpret the EU law, and none of the international agreements, meaning BITs in this case, cannot make any effect or change this, what has been provided by the Lisbon Treaty. But what is really interesting, this is, I think everybody knows more or less what was the ACMEA about, but also I think that was a very important thing and would raises questions, because it is what's said here that basically the European Court of Justice, he said that the commercial arbitration can apply European law. By the way, this is the regular continuation of this, what was said many years ago in ECO-Swiss. But the arbitral tribunal, which are rooted in the BITs, in the investment arbitration treaties, they are not allowed to interpret the arbitration, the EU law. And it is really very difficult, I don't know whether you agree with me or not, but I think it is very difficult really to find out what is the basic difference between commercial arbitration and investment arbitration. Basically, it is said that in case of commercial arbitration, we have freely expressed wishes of the parties, which a contrario means that when the state contracts the treaty with the other state, it's not really free to make it. And that versus state agrees to remove from the jurisdiction. I can't really find very logical links between those two things. Anyway, I think maybe if there's time, I will come back to this at the end. So what happened next? This is the next thing. What happened was what is going on? What is the fate of this Energy Charter Treaty? There is the multi-party treaty. As I said, this is a very special creature because it is basically with the participation of European Union per se. This is the partner to the Energy Charter Treaty. This case was raised by the Swedish investors versus Germany, and the tribunal issued the special decision of ACMEA. It was titled Special Decision of ACMEA. It was issued at the end of August 2018, so it was quite fresh. And there is a lot of arguments which are raised by the parties and, well, respondent by claimant, by amicus curiae, which was the European Commission as such. And I can sum up in a very short what has been said there. First, I think what was very important for the entire interpretation of the treaty, of the Energy Charter Treaty, was the statement that interpretation of the of the Energy Charter Treaty will not be based on the principles of the EU law. It will be based on the principles of international law, and for these purposes, the EU law was not qualified as such. So, therefore, the tribunals focused on the Vienna Convention on Law of Treaties only, and simply explained the meaning of the provisions of the treaty, basically Article 26 and Article 25 of the ICSID, because that was arbitration which was run in the ICSID venue. They literally interpreted the content of this treaty. The second thing was that, as I said, that was the mixed agreement, and that was the role of the EU as the party to the agreement. And what was basically said, that the European Union, when they were signing the treaty, they could have made certain carve-outs, but they did not. In order to make certain carve-outs from this treaty, they should have made explicit, in wording, explicit exceptions, something what has been done. They also used the formal argument. So first thing, it was that they should have made certain special exclusions, so that in order to exclude EU member states from full implementation of the treaty. And secondly, they also used such an argument, which is, I believe, more formal, that in the opinion of the general attorney, which was submitted in ACMEA case, there was a distinction between investment arbitration, between the Energy Charter and other BITs, bilateral agreements, and that European Court of Justice did not really took into effect, did not really rejected this, that there is a different regime. The final argument, which was done by the tribunal, it was based on this Article 16.2. Sorry, I think it was 16.2. And I think that this is quite clear, that it was said also by the European Union as a party that there will be no prior or subsequent treaties which shall be construed so as to derogate from any provision in Part 3, which is investment promotion, and in particular, including the substantive protections of Part 5, dispute settlement. So that was like a basic argument used by the tribunal, that even if the rest of the arguments failed, that was the really very important one. I will not focus on all of the arguments, because there was really a number of them. What I would like to conclude with, I think that there can be a conclusion in the short run or in the long run. The first conclusion is that in the short run, that oil and gas arbitrations should be safe based on this ruling, on this decision of the arbitrators. Bearing in mind that Energy Charter Treaty is a mixed agreement and differs from the BITs. But I would say, just in case, I would say that it is convenient to have this proceedings, this dispute resolutions made according to the ICSID rules, in order to use the benefit of this delocalization in case of the finality of the awards. It is not perfectly safe, because recently that was also raised the argument that was raised argument of the case Terra RAF Trans versus Kazakhstan, where it was a little bit generated from this case that in case there was the Gibraltar company against Kazakhstan, and the arbitrators drawn their jurisdiction based on the fact that Gibraltar, although it does not really belong to UK, not to Spain, but this is in the territory based on the agreement, it is a territory of UK. So as such, as a general territory, it can be subject of the use protection of the Energy Charter, and in this case, if there is the EU member state, it might be treated in this way that there are double nationalities of such a investor coming from one of the EU member states, because it will have like a nationality of a member state and plus nationality as the EU area as such. That was not exactly dealt with here, but that is something what should be really considered. In the long run, I will not right now talk about Brexit, because this is the more general subject, how Brexit will impact the fate of the UK as a party to this treaty. And I think that also there is a general, very interesting thing, which is issue, which is also important for the commercial arbitration. As you remember, I have shown this one paragraph which said, what is the difference? Why commercial arbitration can apply EU law and the investment arbitration cannot apply the EU law? I think that, I hope that this will not be developing into the wrong direction. It means trying to limit also the commercial arbitration, especially if we call back to 2010 and 12, when there was a discussion about Brussels I directive, where there were voices in order to grant arbitration tribunal the right to submit the preliminary questions to the ECJ, and that was absolutely not approved by the arbitration community in Europe. And the Brussels I directive right now has the full exclusion of the arbitration from the framework of the European law. Thank you very much. I hope I was not too late.